Welcome, this is Cinzia from the University of Verona, and this presentation focuses on Kafala and the European and Italian perspectives. Kafala is an institution widespread in Islamic countries under which a couple or single persons may take care of orphaned or otherwise abandoned children until they come of age. By virtue of this relationship, no legally binding link is established with the family receiving the child, and the powers of representation or protection remain with the competent public authorities of the country of origin. This protective measure may be granted by agreement between the parties, the so-called private or consensual kafala, which may then be approved by the competent authority, or by a court order, the so-called judicial kafala or notarized instrument. The specific status of the measure is significant in terms of both its classification and recognition under the legal system of the hosting country, since it could give rise to difficulties as to its compatibility with the public policy of that country. Kafala is specified as one of the measures for ensuring the protection of and care for abandoned children under the 1989 New York Convention on the Rights of the Child, namely its Article 20, Paragraph 3, and the 1996 Hague Convention on Parental Responsibility and Protection of Children, especially its Article 3, letter E, by which all member states of the European Union are bound. It must be noted that the contracting states to this convention also include some countries of Islamic origin, which may have not, in fact, acceded to the 1993 Hague Convention on Inter-Country Adoption. The recognition of kafala requires its preliminary classification and thus to determine its nature, features, and effects in order to meet the conditions for the request, for instance, to grant family reunification, to declare adoption, to grant parental leave. Within the European framework, there are no specific provisions governing kafala. The Union does not have any competence in matters of parental status and family law. However, the Union shares competence with the Member States in the field of judicial cooperation in civil matters in order to regulate cases with cross-border implications. In that context, the Brussels IIa regulation on parental responsibility has been adopted, and Article 1 of which does not, however, mention kafala as one of the measures falling within its scope. Therefore, although there are no European Union rules governing kafala, thanks to the applicable international conventions, the Islamic institution deserves protection and should be considered as one of the arrangements for providing care to minors that must be recognized under the European legal order. In the European context, thus, the recognition of kafala has never been addressed, but it was brought to the attention of the Court of Justice for the first time within a question concerning both the right of Union citizens and their family members to move and reside freely within the member states, governed by Directive 2004 number 38, and the possibility to recognize a child placed under kafala as a direct descendant of the European citizens involved. The Grand Chamber affirmed that the concept of the direct descendant of a European citizen under Article 2, Paragraph 2, letter C of the Directive must be interpreted as not including a child who has been placed in the permanent legal guardianship of a European citizen under the Algerian kafala system, because that placement does not create any parent-child relationship between them. However, the competent national authorities shall facilitate the entry and residence of such a child as one of the other family members, pursuant to Article 3, Paragraph 2, letter A of that directive, taking into account the right to respect for family life and the best interests of the child. Whenever the child under kafala and its guardian lead a genuine family life and the child is dependent on its guardian, that child should be granted a right of entry and residence in order to enable him or her to live with its guardian in the host member state. Italian courts also addressed the provision of care by kafala, not only with reference to the request for family reunification, whether made by Italian or third country nationals, but also with regard to other issues such as adoption or parental leave. Overall, a common approach has been adopted within the case law, according to which the Islamic institution is not equivalent to adoption, but is rather similar to foster care, as affirmed in 2013 by the joint divisions of the Italian Court of Cassation, which is thus in line with the Court of Justice interpretation. The nature of the Islamic measure of protection raised doubts about its recognition in Italian legal order. The Supreme Court confirmed that family reunification should be granted when the child has been entrusted to its guardian under a judicial kafala, but also private kafala concluded by an agreement and subsequently approved by the competent court of the place of origin of the child could be deemed a valid basis for family reunification, since the public authority verified the conformity of the act with the best interest of the child. And this was recently confirmed in November 2020 by the Italian Court of Cassation, where again, the best interest of the child were given prevalence. In conclusion, the Italian court's interpretation of the kafala measure is in line with the Court of Justice judgment as regards family reunification, even if in the domestic legal order a comprehensive framework governing kafala after the ratification of the 1996 Hague Convention is still missing. Some questions could be put forward regarding whether the Court of Justice ruling could be valid also in other family matters, and above all, whether the Union should adopt a common uniform legislation insofar as the 1996 Hague Convention does not apply to ensure the respect for the right to family life in combination with the best interests of the child. Thank you.